Здравствуйте, Игорь Иванович, здравствуйте.
Добрый день, рад вас видеть.
Да,
С прошедшим днем рождения, у вас позавчера был день рождения.
Да, спасибо, спасибо. Я сейчас в Кыргызстане, в Бишкеке нахожусь.
О,
Так что мы здесь с вами соседи.
Добрый день, уважаемые коллеги.
соседи.
Да,
Добрый день. Сергей Федорович, всем огромный привет.
Здравствуйте, Рамазан Кумарбекович. Марат Муратович, добрый день. Институт Сорбонна вас, Казахстан, приветствует.
Здравствуйте, уважаемые участники круглого стола. Всех вас приветствую.
Добрый день всех рада видеть. Добрый день.
Наталья Виссарионовна, добрый день. С днем рождения вас.
Спасибо большое, Марат Муратович, спасибо большое.
Наталья Виссарионовна, еще раз с днем рождения, 3-й раз сегодня.
Спасибо, спасибо, Рамазан Кумарбекович, спасибо.
Вечером еще встретимся.
Обязательно, обязательно.
Добрый день, уважаемые коллеги.
Добрый день.
Nice to meet you, my dear colleagues. Наталья Виссарионовна, день рождения, говорят, да?
Да, спасибо.
Поздравляем. Сегодня такой
Спасибо.
день особенный.
Спасибо,
Успехов.
спасибо большое.
Благополучия, здоровья.
Спасибо, Долгос Петрович.
Қайырлы күн. Ал кейбір форумға қатысушылар үшін қайырлы таң, құрметті әріптестер, ханымдар мен мырзалар. Қазақстан Республикасы.
Good morning and good afternoon, dear participants of the forum. I would like to welcome you and thank you on behalf of the Constitutional Court of the Republic of Kazakhstan. Distinguished participants, this forum is being held as part of the joint program of the strategic partners of Kazakhstan, the European Union and the Council of Europe on the rule of law in Central Asia. This meeting is arranged by the Constitutional Council of the Republic of Kazakhstan together with the Venice Commission and the Council of Europe. And as you know, the Venice Commission has a huge expert potential when it comes to the issues of constitutional control, justice, and the rule of law. This forum is devoted to the issues of further improvement of the referral by courts to the constitutional control bodies, and the Constitution of Kazakhstan has established the mechanism of the intermediated referral of citizens to the Constitutional Council through the courts of the Republic. And as the experience shows, the momentum of the work of this institute cannot be called positive. The Constitutional Council, in its messages or addresses, had repeatedly indicated the necessity to use the capacity of courts in order to make referrals to the Council. about the legality of the acts. And last year, the special draft law has been developed together with the parliamentarians. Right now, the Constitutional Council has submitted its specific proposals to the president of the country. And as the initiative of the parliamentarians and the proposals of the Constitutional Council caused discussions among some government bodies, we decided that it would be right to discuss legal and other aspects of their implementation together with the stakeholders and international experts. Overall, the mechanism of the inspection of the constitutionality of legal acts is aimed at strengthening the guarantees for human rights and development of the legal system of a country with the leading role of the Constitution. And according to the foreign practices, the Institute of the Constitutional Appeals is quite common, and that allows the citizens to initiate the inspection of the constitutionality of laws that touch upon their rights and legal interests. In a number of countries, this is combined with the appeals by the courts to the constitutional control bodies, and it shall be noted that these institutes work quite effectively. We will have to thoroughly look at the recommendations of international human rights institutions, and the Venice Commission, in its opinion about Kazakhstan, recommended to expand the list of subjects for the referral to the Constitutional Council, especially when it comes to the assessment of the constitutionality of legal acts. Back in 2007, the Venice Commission submitted the proposal on attributing such a right to the Human Rights Ombudsman. And this idea also deserves a more careful attention, especially in the light of the preparation of the special law on ombudsman. Dear colleagues, today we have the representatives of the Parliament of the Republic of Kazakhstan, the representatives of the government bodies, human rights institutes, and the academic circles of the Republic of Kazakhstan, international experts representing the OSCE, Venice Commission, and many other international organizations. I'm sure that this roundtable will make it possible for us to exchange opinions and develop optimal solutions to existing problems. Let me declare our meeting open, and let's begin to our introductory remarks. The first floor goes to the President of the Venice Commission of the Council of Europe, Mr. Gianni Bucchicchio. Mr. Bucchicchio is a true proponent of democracy, and he is a great friend of Kazakhstan. The floor goes to you, Mr. Bucchicchio.
Микрофон включите, Джанни.
Please don't forget to unmute yourself.
Can you hear me? Dear Ambassador Madsen, ladies and gentlemen, I would like to welcome the initiative by Chairman Mami of convening us to this online roundtable on the referral of cases to the Constitutional Council by ordinary courts. My warm thanks to the European Union delegation for supporting this event in the framework of the Central Asia Rule of Law Joint Programme. Chairman Mami, I also would like to thank you for your trust in the Venice Commission as expressed through your request for an opinion on the concept paper on improving the legal framework of the Constitutional Council of the Republic of Kazakhstan. This two-pronged approach, roundtable and opinion, allows us to discuss this important topic both on the scientific and on the practical level, based on comparative experience in Europe and in Asia, and to examine this topic on the basis of the Constitution of Kazakhstan and its specific needs. I am pleased that all three rapporteurs for the opinion, members of the Venice Commission from France, Korea, and the Republic of Moldova, are here with us today. We will greatly benefit from the experience in their respective countries. Chairman Mami, your request is timely. Only last December, the Venice Commission updated its report on individual access to constitutional justice. This report highlights the importance of the referral of cases from the ordinary courts to constitutional courts as a key access path to constitutional justice for the citizen. This comparative report makes a distinction between diffuse and concentrated constitutional control. In countries with a diffuse control model, such as the United States, all judges review the constitutionality of laws, whereas in countries with a concentrated review model, as it is the case in most European countries, it is the Constitutional Court or Council that carries out these tasks. An obvious advantage of the concentrated review model is that it leads to greater unity of jurisdiction and ensures legal certainty, as only one court can invalidate legislation in force. In countries that use a concentrated review model, preliminary requests allow ordinary courts to refer constitutional issues for decision to the Constitutional Court or Council. Such preliminary requests, which are sometimes called exception of unconstitutionality, exist in most states that use a concentrated constitutional review model. They constitute the most common method of indirect individual access. Depending on the model chosen, a preliminary request can be initiated by one of the parties and or by the ordinary judge. In its report, the Venice Commission concluded that from the viewpoint of human rights protection, it is expedient and efficient to give courts of all levels the possibility to directly refer preliminary questions to the Constitutional Court. By establishing a Constitutional Council, Kazakhstan has chosen a concentrated review of legislation and its model for ensuring the conformity of laws with the highest norm, the Constitution. It is the Constitutional Council, which is the body entrusted by the Kazakh Constitution to decide on the constitutionality of legal provisions. In line with the Venice Commission report on individual access, I note with pleasure that your Constitution enables courts of all levels to refer cases to the Constitutional Council. Yet, it seems that this mechanism has not yet been used to its full potential, but it should be further developed. Mr. Chairman, I saw that the concept paper presented by the Constitutional Council intends to reinforce and to render operational the Kazakh system of constitutional review. This is a very positive goal, and I'm confident that this roundtable and the opinion of the Venice Commission will contribute to achieve this objective. Strengthening the mechanism of preliminary request will certainly contribute to the protection of human rights in Kazakhstan. Based on the experience that you will gain with this model, once fully implemented, you could even envisage introducing direct access to Constitutional Court in the long run. Thank you very much for your attention.
Спасибо. Спасибо, господин.
Thank you, Mr. Bukikio. Let me thank you for another joint event and your readiness to provide the expert support on this very important topic. Next floor goes to the head of cooperation of the European Union delegation in Kazakhstan, Mr. Johannes Tenbak-Madsen. Please, the floor is yours, Mr. Madsen.
Надо предупредить тогда.
You should have warned me. Okay, let's continue our work. Mr. Madsen is absent. Maybe he'll join us later. Distinguished participants, now let us start with our reports. Each speaker has a time limit of 10 minutes. Now the first floor goes to Bakhat Nurmuhanov, the chairman of the Constitutional Council. Thank you very much.
Тәжірибе көрсетіп отырғандай, адам құқықтарының бұзылуы конституциялық талаптарға
As the global practice shows the violation of rights and freedoms of people can be the consequences of the application of the law not in line with constitutional requirements. The Institute of Constitutional Control that has a long history relates to the development of the model by Gans Kelsen, who developed the centralized constitutional control model that is entrusted with the specialized state body. Is entrusted with powers on assessment of constitutionality of the current legislation. This system now is effective in the majority countries of the world. Initiators for that review can be a wide circle of parties, in particular courts, ombudsman, and citizens. There is a trend for constitutional complaints of citizens. Lately, it has been introduced in Turkey, Hungary, Ukraine, Lithuania. Constitutional Council of Kazakhstan used the main features of centralized model. It doesn't interfere with the justice questions, and it limits itself to the constitutional review of the legal norm. It should be mentioned that in our country, citizens have indirect access to Constitutional Council via the courts of the country. This mechanism is applied in more than 40 countries. The courts, considering cases, may face the deficiencies of the law. Such issues are pointed out by the litigants. In these cases, the court is obliged to suspend the proceedings and to refer to Constitutional Council. Over the 25 years, the Council received 71 requests from the courts. They were related to the topic of regulation from different areas of the law. At the same time, the potential of this constitutional institute is not fully unleashed. Lately, courts approach the Constitutional Council quite rarely. Last year, 0. In 2019, only 1. In 2018, 2. For comparison, the Constitutional Council of France, since 2010, reviewed about 1,000 requests from the courts. Constitutional Court of Korea last year received 1,005 requests from the courts. In 2019, Constitutional Court of Moldova, 192. Constitutional Court of Azerbaijan, 12. Article 78 of the Constitution of Kazakhstan lays down the mechanism for constructive cooperation of the courts with litigants regarding ensuring the impeccable legal basis that will be used for the judgment on particular case. The judges are aimed to ensure the submitting requests to Constitutional Council that should be considered. They even called as the preliminary filter that will filter ungrounded motions. However, its effectiveness mainly depends on the independence and the level of the education of the judges, especially in the area of constitutional law, and his or her activity and the capacity to identify potentially unconstitutional law, given the loads and other factors. In general, within the framework of provisions of Article 78 of the Constitution of Kazakhstan, there are several options to initiate referrals to the court. It can be the opinion of the judge, him or herself, who arrived at the conclusion on the infringement upon the human rights by the law. Or it can be grounded motion of litigants, even if the judge does not share that. The third option, ideal one, the judge jointly with litigants if they position common. Therefore, we assume that in procedural code, we will straightly allocate such requests, and we will identify more detailed process for their consideration by the court, irrespective of the party that doubted in the constitutionality of the applied law. The decision on the referral to Constitutional Council is taken by the court. This regards the high interests. The questions of assessing the motions of the litigants by the court and the arguments are of high interest. The statements, for example, what if the court thinks whether the judge is entitled during the consideration of arguments of the litigants to take decisions on the law constitutionality? What arguments and facts are sufficient? In constitutional acts of certain countries, there are different statements. For example, if the court arrives at the conclusion, assumes, thinks, if the issue on constitutionality is significant for the case judgment, or if the court doubts in the law constitutionality, or in case of the dispute on constitutionality, or if the court thinks, as it is said in our constitution. So they have similar, however, non-identical meanings. Venice Commission states that the courts should have an opportunity to refer to constitutional courts if they are confident in unconstitutionality of the legal norm. However, the Commission thinks when individual citizens do not have direct access to the constitutional court, like in Kazakhstan, there should be serious grounds, and serious grounds are enough to refer to the court. Therefore, in the number of countries, courts are obliged to refer each time when they find some problems that provoke doubts in constitutionality of norms. In Italy and San Marino, it's enough if the raised question is considered by the court as clearly ungrounded. Therefore, the level of legal knowledge of litigants can be different. Therefore, Venice Commission recommends not to set strict requirements to the arguments by the litigants. From now on, the procedural code of Kazakhstan will fix the active role of the judge. Therefore, the judge should be capable and must help to litigants to properly state their claims to the law and refer them to Constitutional Council in a form of the motivated motion. In a number of countries, before sending this to the court is obliged to discuss this question with the litigants. Some lawmakers think that litigants cannot dictate the court when to refer to Constitutional Council, as it may infringe upon independence of the court. We support the principle of the judge independence, and I would like to mention that during execution of the justice, the judge should follow the constitution and the law. These requirements should be mandatory if there are doubts in constitutionality of the law itself. Stating the motion, the litigants only ask the court to take intermediate procedural decision to send for the constitutional review of the applied law, which is the competence of another body, Constitutional Council. The courts should thoroughly analyze the arguments of the litigants in order to understand whether there are features of arguments and that will impact the final Justice Act on the particular case. The judgments should be taken in the chamber, and they should be stated in the form of the separate documents, and they should be grounded. Among judiciary, there is a concern that these proposals will lead to the abuse by the litigants, where they will abuse their rights and they will delay the judicial process. In order to minimize ungrounded motions, we propose the following requirements: mandatory written form, providing arguments and evidence, if any. Non-fulfillment of these requirements will enable the court to not to meet this type of ungrounded motions. If the court refuses, and this should be the topic for the immediate appeal complaint to the upper courts. If the court judge approaches the Constitutional Council, then the Constitutional Council, if sees ungroundedness of this motion, may refuse to consider this request. So we have a 3-day period. So according to Criminal Procedural Code and Civil Procedural Code, there is a requirement that as an argument for the delay of judicial process, there is a necessity to suspend the judicial proceedings. Well, ideally, it's correct. If needed, this requirement can be softened. However, the court that applies to the Constitutional Council is obliged to suspend its proceedings. With regard to these courts, it can be done as their right. However, the final decision should be on the particular case should be postponed. in the legislation, it is also needed to solve the question or notifying other courts about taking the motion of the court regarding the constitutional proceedings. It can be done by the administrative office of the Supreme Court. The level of digitalization of judicial system enables that. In the practice of constitutional review, there are different mechanisms elaborated that enable to regulate the question on the timeline for bringing into force the decisions of the constitutional councils and its consequences. They are aimed to keep the legal certainty and the balance of adversarial interests. Acknowledging the legal norm as unconstitutional should be perceived as the normal phenomena, and it should be considered as the result of the constructive interaction of constitutional courts, constitutional council, state bodies, and citizens whose claims were heard and resolved. And this comes from the concept of the listening state, which is aimed to ensure the mission of the state apparatus. So in general, this will contribute to strengthening of guarantees of the human rights protection. Thank you very much. Distinguished participants, I hope that the ideas mentioned by the speaker will be also explained in more details further in the further speeches. It should be mentioned that this institute is taken from the advanced legacy of constitutionalism, and it is widely and successfully applied in a number of European countries.
Next floor goes to the chairman of the Judicial Board for Criminal Cases of the Supreme Court of Kazakhstan, Mr. Zhukenov. Zhukenov, Abdurrashid, the floor is yours. Dear colleagues, ladies and gentlemen, good afternoon. On behalf of the Supreme Court of Kazakhstan, I would like to welcome the members of the International Roundtable. I think that the choice of the theme of today's event is not fortuitous because it highlights the special role of courts in terms of ensuring constitutionality and the rule of law, which is a key factor for the development of society, economy, and political institutions. The courts are the guarantee of the protection of the rights and freedoms of a man and a citizen, and the interests of the society and the state enshrined in the constitution of the country. The relationship between the Constitutional Council and the courts is based on the norms of the constitution and relevant constitutional laws that determine their status, purpose, special functions, and powers. Their work is linked to common tasks and effective implementation of the principles of constitutionality in all spheres of public relations, which is determined by the processes of law creation and enforcement of laws. Article 78 of the Constitution says that the courts are not entitled to apply laws or legal acts that infringe on human and civil rights and freedoms, which are enshrined in the Constitution. In this case, the court is obliged to suspend the proceedings and apply to or resort to the Constitutional Council with a proposal to declare this act unconstitutional. Similar norms are contained in the procedural laws of the Criminal Code, Administrative Code, and CPC. The court also, according to procedural laws, at the request of the parties, is obliged to suspend in full or in part the proceedings on the case if the Constitutional Council, on the initiative of another court, has accepted for proceedings a submission on the recognition of a law or other normative legal acts to be applied unconstitutional. As regards the order of execution by the courts of Article 78 of the Constitution, also paragraph 2 of the decree of the Supreme Court from May 14th of 1998 on some issues of application on the legislation of on the judiciary in the Republic of Kazakhstan. This order also provides a better explanation, and the Constitutional limits the list of subjects of appeal to the Constitutional Council. The individuals and legal entities do not have this right, and the participants can declare that the legal norm must be applied. However, even if it's unconstitutional, the petition to the court will be submitted accordingly. This is prescribed by Article 99 of the Criminal Procedural Code or Article 195 of the Code of Civil Procedure and Article 740 of the Administrative Code. Thus, the courts are kind of a bridge for the citizens' access to the Constitution, to the institution of constitutional control in relation to existing laws and other legal acts. In terms of initiation of inspections of constitutionality, well, that has already entered into force, and there are still some shortcomings and gaps of the law which are not visible in the process of the adoption, but they can be identified in the process of enforcement. The basis for the appeal to the Constitutional Council is the discretion of the court, including the petitions of the participants in the process, and the discovery or establishment by the court of the fact that the applicable law or a legal act restricts the constitutional rights and freedoms of a man and citizen helps a lot here. As noted by the Constitutional Council in its resolution number 6/2 from March 5th, 1999, the court, when applying to the Constitutional Council, shall come to the conclusion that the act to be applied in the case is unconstitutional. A prerequisite for the implementation of the powers of the court provided for in Article 78 of the Constitution is the existence of the case, which, in accordance with the paragraph 2 of the Article 75 of the Constitution, is considered by the court through civil, criminal, and other forms of legal proceedings established by the law. Since 1996 till 2020, the courts of the Republic submitted 71 submissions to the Constitutional Council, which is more than 1/3 of the total number of appeals received by the Constitutional Council. Out of them, 40 complaints were received on proceedings, and 31 complaints were declined. On 9 of them, the constitutional proceedings were terminated, including the 6 of them which were terminated in connection with the rejection of the claim treatment. Thus, the Constitutional Council had reviewed 31 appeals. 10 complaints were satisfied under other legal acts. For example, on the proposal of Kapshagay City Court of Almaty, under the resolution of the Constitutional Council dated from February 27th of 2010, the parts 1 and 4 of Article 361 of the Criminal Code of 1997 provide for liability for self-harm. And it's recognized that this provision of the Criminal Code allows for the arbitrary prosecution of citizens and does not correspond to the item 1 of Article 39 of the Constitution of Kazakhstan. Pursuant to the recommendations of Constitutional Council and the law from December 10th of 2009, Articles 360 and 361 of the Criminal Code are set out in the new edition. So, according to these articles, the responsibility has been established for self-harm and for the organizing of group disobedience to the legal requirements of the administration of the institution of the penitentiary system, as well as for the participation in the group disobedience associated with the deliberate infliction of any harm on anyone. According to the constitutional paragraph of the Constitutional Council of April 23rd, 2008, the proposal of the court number 2 of the city of Kostanay region says that the norm of subparagraph A of paragraph 1 of Article 25 of the law of the Republic of Kazakhstan, the state registration of rights to immovable property and transactions with it, this provides a basis of refusal to accept documents for state registration of immovable property and transaction, with it missing the deadline for submitting such documents. The government of the Republic of Kazakhstan recommends to consider the issue of initiating amendments to existing legislative acts in order to bring them in line with the legal positions of the Constitutional Council of Kazakhstan. And in order to fulfill this decision, the law of the Republic of Kazakhstan from April 22nd of 2009, particularly the subparagraph 6 of paragraph 1 of Article 25, was excluded from the law on the state registration of rights to real estate and transactions with it. About 20 ideas of legal acts are considered unconstitutional. At the same time, in some cases, the Constitutional Council recognizes the need to adopt legislative measures. For example, according to regulatory decree from July 3rd of 2008, 18, taking on the representation of Karagandi Regional Court. Article 5, paragraph 27 of the law on enforcement proceedings and the status of bailiffs to be consistent with the Constitution. At the same time, in order to prevent the infringement of human rights and civil rights and freedoms, in order to fully regulate the procedure for implementing this work, the Constitutional Council recommended that the government considered the initiation of the amendments to this law. Taking into account this legal position of the constitutional law from January 21st of 2019, the law on enforcement proceedings and the status of bailiffs was supplemented with the new Article 31/1. In conclusion, I would like to note once again that this current state of appeal to the Constitutional Council by the courts is an effective mechanism for ensuring constitutional legality, the rule of law, the rights of freedoms of man and citizen guaranteed by the Constitution. Thank you for your attention. Thank you, Abdrashid Tuligenovich. I would like to note that the decree of the Constitutional Council dated from March 5th of 1999 that you've been referring to in your speech is not a normative decree of the Constitutional Council, and it relates to the procedural issues only. That is why we cannot state with confidence that this issue is resolved. You are one of the renowned specialists of the Supreme Court of the Republic of Kazakhstan. That is why I believe that you are very well informed about all the legal acts and norms. So that legal act that you are talking about is only of a procedural nature. If that is not really clear for courts, the Constitutional Council can provide additional information on this legal act in order to bring in more clarity in an official manner. When it comes to constitutional rights and freedoms of citizens, and well, it is really important for the courts to fully understand them. That is why the example that you provided in your report about the Constitutional Council that adopted a number of decisions in recent years, I think is highly important. That is why, hopefully, the courts will closely interact with the Constitutional Council in the future in order to make joint decisions. Next floor goes to the Deputy Prosecutor General of the Republic of Kazakhstan, Mr. Marat Ahmedjanov.
Distinguished Mr. President, distinguished participants of the round table, I would like to thank for having this opportunity to deliver a speech at such a reputable event. The consideration by the Constitutional Council of the requests from the courts according to Article 78 of the Constitution is one of the mechanisms to ensure the supremacy of the basic law. The fact how the system is built and works depends the most important, which is the protection of rights, human rights and freedoms that are acknowledged by the Constitution as the supreme values of the state. In these directions, the tasks entrusted by the Constitution to the Constitutional Council and General Prosecutor's Office are common on many parameters. The Constitutional Council will ensure constitutional legality, and the Prosecutor's Office the supreme supervision over the legality. Prosecutors, by implementing the supervision on a daily basis, apply legislative and other legal acts. If there are acts detected that are controversial to constitution, laws, or presidential decrees, or ratified international treaties, the prosecutor's office will challenge them. And this procedure is quick and simple. And it should be mentioned that before constitutional reform, the prosecutor's office had the right to challenge the laws, but this mechanism didn't work. And the general prosecutors are not referred to the subjects that may refer to Constitutional Council, and are entitled to refer to them only with motion about understanding of the and reviewing the decree that was taken before. Thus, in 1998, Jambil Regional Court, at the initiative of the prosecutor, sent to Constitutional Council its request. Back then, the council acknowledged as unconstitutional certain provisions of that document. Article 78 of the Constitution mentioned that if the court decides that the law or other legal act infringes upon the rights and freedoms of individuals, the court is obliged to suspend the proceedings and to approach the Constitutional Council. The practice of constitutional proceedings shows that when taking for proceedings the request for Constitutional Council, here the defining and decisives are the arguments of the court itself, how this challenge norm infringes upon constitutional rights. For example, in 1999, the representation of the Supreme Court was not accepted as the court didn't indicate where the court found the infringement upon the constitutional rights of a citizen as it is required by the Article 78 of the Constitution. At the same time, it should be mentioned, the previous speakers have shown that other countries, for example, like in Korea, per year, more than 1,000 representations are submitted to the courts or councils. But here, it should be mentioned that in Kazakhstan, like in every country, there is an individual process. Here in Kazakhstan, the process of adoption of the law, there is a certain filters starting from the legal review, legal expertise. Moreover, we have a two-chamber system in the parliament where they can block each other's decisions. So these numbers can be perceived differently, but not as a negative balance. However, at the same time, I would like to mention that, as I have said, the prosecutor's office has a right to challenge any legal acts and implements the supreme supervision. Therefore, only for 2020, last year, 7,947 legal acts were challenged in local and central executive bodies. However, it should be mentioned that mechanisms for considering such motions and requests submitted to the Constitutional Council should be improved. The amendments to the procedural code were discussed by us and supported by us. We think they are aimed at solving this issue and at strengthening the human rights. At the same time, it should be mentioned that a number of questions, a number of proposals questionable. We think that certain amendments have risks of violating the constitutional principle of judges' independence and equality in front of the law. And this is about the refusal to accept the motions to the Constitutional Council. The draft, the question on the necessary approach to the Council will be taken not by the courts, will be decided not by the courts, but by the above courts. So this will be decided not at the discretion of the judge that should apply this legal act, but at the decision of other judges. Here we think that the principle of judges' independence is affected, which is fixed in Article 77 of the Constitution. At the same time, the provisions of Article 78 of the Constitution are also eliminated, as from this article it goes that the referral to the Constitutional Council should come from the court that has the proceedings, where the proceedings are, and the court that at its discretion that understood that the applied law infringes upon the rights and freedoms. So here there is a question whether this approach affects the principle of the equality of everyone in the courts. It turns out that the other party doesn't have this right for challenging And if the court refuses to accept this challenge, the parties, the litigants can proceed with the appeal. We think that this will be also discussed and considered by experts. And I would like to finish by saying that in order to tackle all uncertainties, Constitutional Council should give official interpretation of Article 78 in the context of the statement if the court decides to explain what does it mean. Thank you for your attention. Thank you very much. Marat Muratoglu, the prosecutor's office as the supervisory body can contribute to ensuring the constitutionality of the legal framework and can contribute a lot. And your report, your speech confirms that. Thank you very much for supporting our draft. So let's continue our discussion. And I would like to pass the floor to the member of the Constitutional Council of France, Vice President of the Venice Commission, Ms. Claire Bazi-Mallory. Please, the floor is yours.
Thank you, Mr. Chairman.
In 2008, so it's not long ago, France has introduced a posteriori review alongside the existing a priori review of the constitutionality of acts. And France veered away from its traditional reluctance towards judicial control of legislation, introducing then the priority preliminary ruling procedure, which is named in French question priorité de constitutionnalité. This procedure allows any individual, a citizen or a legal person, to challenge before an ordinary judge the constitutionality of a legislative act which allegedly restricts their rights and freedoms. The a posteriori constitutional review in France is an abstract review. The challenge provision is reviewed as a norm, notwithstanding to the particular circumstances of the case, which the sort of the question raised for review. It refers only to the infringement of the rights and freedom guaranteed by the Constitution, but in France, many of them lie not only in the Constitution itself, but also in the preamble, and nowadays in the Charter for the Protection of the Environment. So there is no direct access to the Constitutional Council. And well, I'll point out 6 points. First, anyone involved in judicial proceedings can ask for such a review, but the judge himself cannot ask for a review. It belongs only to the parties. The specificity of the French system is that it provides for a two-level filter system for referring preliminary questions. The first level is the court in front of which the question is raised. This court refers necessarily to the Cour de Cassation or the Conseil d'État if it is an administrative court. Only this Supreme Court, thus involved, may refer the question to the Constitutional Council, but it can happen, of course, that the question is raised for the first time before one of those two Supreme Courts. This allows to escape from a risk of overburdening the Constitutional Council, especially considering that there are only 9 members in the Council and that it was considered difficult to ask them or part of them to decide what questions deserve a decision of the Constitutional Court. There is no cherry picking. To give a measure of the risk of overburdening, from the beginning in 2010, the Constitutional Council made an average of 80 decisions QPC a year, and it is the result of the work of the second level filter, which refers only about 25% of the referrals received. 2, all along, the procedure is written. on pain of inadmissibility, a party contending that a statutory provision infringes rights and freedoms guaranteed by the Constitution shall present this argument in a separate written reason memorandum. This kind of separate memorandum is requested all along the procedure. It applies also for other commands put forward by the parties on the application. At every stage, up to the Constitutional Council, such a written memorandum is compulsory on pain of inadmissibility. The court is bound by the analysis made by the applicant. It is bound by the grievances. This is made to allow the court to leave to the litigant the dispute and to oblige it to answer completely on the ground of the criteria for admitting the referral provided for by the law. It also allows to refuse to accept manifestly ill-founded, frivolous, abusive, or repetitive complaints. The law specifies that legal representation is mandatory before the Constitutional Council, but the courts have their own rules on the representation and they're not modified for this review. And there is no appeal for challenging the refusal to transmit an application itself, but the challenge could appear as part of an appeal lodged against the decision settling all or part of the litigation. A written reason memorandum accompanied by a copy of the decision of refusal to transmit the application is then required. 3. The law provides for criteria as grounds for referrals. 2 of these criteria are common to all levels. The third is slightly different. We can put this criteria with question marks. Was the harm caused by the alleged unconstitutional act, and was this act the legal basis of the proceedings underway? Has the statutory provision already been referred to the Constitutional Council? And as the third one, the first level has to say whether the question appears to be serious, which means whether they detect issues that could create doubts concerning the constitutionality of a provision when they need to apply in a given case. Whereas the Cour de Cassation and Conseil d'État have to say whether the question is a new one and a serious one, which requires, in fact, a more profound analysis. 4. The judicial proceedings are interrupted by the admissibility of the application. If there are motives not to suspend the proceeding, for instance, when somebody is in jail, the judge can rule immediately. He can also take interim measures. The first judge shall rule without delay at the first level. The second level, we name it, in fact, the filter, must give its decision within the delay of 3 months. If there is no decision in the time limit, the question is directly referred to the Constitutional Council. And the Council itself has 3 months to make its decision. These time limits are set to make sure that the proceedings which were stopped because of the preliminary ruling procedure resume in the shortest possible time. And in some cases, it could take only 6 months from the first memorandum to the final decision. 5. Constitutional proceedings are adversarial. Not only before the Constitutional Council, the Prime Minister, as the Chief of Administration, is present, but other litigants involved in similar procedures and defenders of the law can also appear before the Council, and various persons interested in the claim, such as associations, can participate in the dispute. It means also that if the Council finds a useful grievance which did not attract the attention of the litigant, it has to submit it to all the parties for discussion. The procedure is necessarily written, but all hearings are always organized and they are public, even available on the internet on the same day. 6. Decisions of the Constitutional Council have erga omnes effect. They are binding on all public authorities as well as all courts. Of course, there's no problem for a decision confirming the constitutionality of an act. In the court, the proceedings resume. A decision of unconstitutionality invalidates the normative act ex nunc. The provision cannot be implemented anymore. As exactly said in the Constitution, the provision is repealed as of the publication of the decision. But the Council may choose a subsequent date. It can also determine the conditions and the limits according to which the effects produced by the provision shall be liable to challenge. There begins difficulties, even sometimes major difficulties for the Council, because many different situations and many different solutions could be on the table. The main issue is in fact for the litigant with this question: what will be the useful effect of the decision for him? Actually, the answer could be none. I will not elaborate on that point, which requires some time. Well, in concluding this short presentation, the Constitutional Council had to take over a complete new function 10 years ago. It has to design new working methods very rapidly. It took exactly 2 years to build them and write the laws and decrees. The first years were intense years of work because many questions then arrived in the Constitutional Council. 10 years after, we asked academics to review our work, and beyond some relevant critics, many valuable comments, and few propositions for change, I can say that satisfaction was the overall judgment. So I wish you full success for the changes you will implement. Spasibo za vнимание.
Thank you for your attention. Thank you, Madam Bazi Mallory. We've been working with you for a long time, and we enjoyed listening to your speech because there are a lot of commonalities between the work of the constitutional councils of Kazakhstan and France, and you made it clear even more. Thank you so much again for your speech. Next floor goes to the Deputy Secretary General of the Constitutional Court of the Republic of Korea, substitute member of the Venice Commission, Mr. John Won Kim. The floor goes to you.
Thank you, Mr. Chairman. It's my great pleasure to be able to discuss on the matters of constitutional justice of Kazakhstan. I would like to share the experiences of the Constitutional Court of Korea. Relevant to the matter on the motions of the parties, the Constitutional Court of Korea has jurisdiction over the constitutionality of a law upon the request of the courts. And the Constitutional Court Act makes it clear that ordinary courts shall address adjudications of constitutionality of the law to the Constitutional Court ex officio or by their decision upon a motion of a party. The motion of a party shall be in written form, stating matters on the content of the law and the reason why the party think unconstitutional. The reason need not be specifically stated. It is only necessary to point out which right, such as freedom of speech, or which constitutional principle, such as equality, has been violated. In Korea, nearly all the cases that have been referred to the Constitutional Court by ordinary courts were made upon the party's initiative. Without the motion of a party, it would be hard to find the necessity of reviewing constitutionality of a law. When an ordinary court refers to the Constitutional Court on the basis of the motion of the party, the ordinary court's written request shall include the specific matters, such as reasons why the statute is interpreted as unconstitutional. From this point on, the judge's worries begin. This is because there is a burden to write the unconstitutional argument fairly convincingly. Let me talk about the joke. In case the motions of the parties to request the referral to the Constitutional Court is filed, the case remains dormant in the cabinet until another case is solved. Of course, it should not remain asleep, but it takes time for full consideration. In case of a referral to the Constitutional Court of the Korea, the proceedings stay in the ordinary court until the Constitutional Court makes a decision on the constitutionality of the law. Since the structure of the Constitutional Court Act of Korea differs from those of other countries, it would be at the disposal of the authorities to find a desirable way. To this end, a profound examination of the law on the constitutional body and related procedural laws would be needed. I will move on to the issue on the refusal of ordinary courts. In Korea, there is no means of appeal to a higher court against a lower court's refusal of the motion to referral to the Constitutional Court. But in the event of a refusal, there is an open way for the applicant to file a constitutional complaint directly to the Constitutional Court. If a motion is denied by an ordinary court, the party may request adjudication on a constitutional complaint directly to the Constitutional Court. In this case, the party cannot file a motion to another court, for example, higher court. The party has only one chance. We need to alleviate the legal complexity of procedures reaching the Supreme Court. Therefore, sometimes the Constitutional Court of Korea can declare the law unconstitutional after a final decision of an ordinary court was made. In that case, the party comes to have a right to appeal for reopening the trial to the ordinary court. Next, I will talk about the effect of the decision of the Constitutional Court of Korea. In Korea, a law found unconstitutional by the Constitutional Court loses legal force from the date on which the decision is made. We have erga omnes effect. The decision comes into effect at 0 o'clock on the day of the ruling, regardless of when the ruling was made, AM or PM. It gives a kind of retroactive effect. In case of a decision found not conforming to the Constitution, the law loses legal effect after a specific period of time specified by the Constitutional Court. The Constitutional Court of Korea urges the Parliament periodically, twice per year. Such measures are not mandatory, but has the nature of a notice or reminder. The Parliament in Korea is always keeping an eye on the decisions of the Constitutional Court. Respect and cooperation would be needed. To be or not to be, that is the question. To refer or not to refer, that is the question. The Venice Commission has dealt with this issue in revised report on individual access to constitutional justice. On this occasion, ordinary courts may be usually concerned with two things. One is the risk of delay of the judicial system, and the other is the fear of application of unconstitutional laws on their cases. We would not have to worry about overburdening ordinary courts with so many preliminary requests on the parties' initiative, because the parties themselves would also be aware of the risk of delay in their cases. Let me show you an example. Last year, 2020, 20 cases have been referred to the Constitutional Court of Korea by ordinary courts, and 744 cases have been directly requested to the Constitutional Court of Korea after denying the motions of the parties by ordinary courts. The Constitutional Court of Korea was established on 1st September 1988, and one case had been directly requested that year. 15 cases in 1989. Numbers don't matter. What matters is what remedies exist. In this regard, it would be helpful to introduce the attitude of the Constitutional Court of Korea. The Constitutional Court of Korea requires a reasonable suspicion beyond a simple doubt on constitutionality. This attitude can be understood as an intermediate position between a simple doubt and the conviction required by German Federal Constitutional Court. The difference seems to stem from their jurisdiction. In Germany, final judgments of ordinary courts can be challenged in the form of constitutional complaint. Therefore, in case of the ordinary court's refusal of the request to address to the Constitutional Court, there is still a room for constitutional review in the Constitutional Court. On the contrary, judgments of ordinary courts themselves are not subject to challenge in Korea. Above all, respect and cooperation are needed for both judicial and constitutional organizations to increase confidence in the judicial system. The increase in the number of cases referred to the Constitutional Court is not an issue. An active request of ordinary courts for constitutional review is a crucial factor to revitalize the constitutional adjudication. Two viewpoints exist in two state bodies, an ordinary court and a constitutional court. My 20-year experience as an ordinary judge and current position as a constitutional expert for 10 years are telling me that two different functions eventually originate from one body. However, there are possibilities that they may cause conflict on legal issues. This is unavoidable because it is a part of the system. I wish that this conference today will contribute the development of constitutional justice of Kazakhstan. And thank you for listening.
Thank you very much, Mr. Kim. For us, the experience of the Republic of Korea, as well as the constitutional complaints of the citizens and referrals to the courts, your experience in this regard is quite important for us. So please convey our regards, the best wishes to our Korean colleagues. The next floor goes to the former chairman of the Constitutional Court of Moldova and the member of Venice Commission, Alexandra Tenasa. Please, the floor is yours.
Speaking Russian to better understand. Уважаемые коллеги, я с большим удовольствием представлю.
Distinguished colleagues, with a great pleasure, I will present the experience of my country when considering specific cases for unconstitutionality and the difference from our other countries. This mechanism works thanks to Constitutional Court. In the Constitution, since the very beginning, we laid down the mechanism for consideration of specific cases of unconstitutionality that were sent to the Constitutional Court by the courts, but due to certain deficiencies in the law, this mechanism didn't work during the 22 years. And during 22 years, we had only 10 judgments on such type of cases. But when we made this decision and when we unblocked the system, now on the agenda of the Constitutional Court, there are more than 95% of all cases considered by the courts are coming from the courts and not from political environments. And Constitutional Court mentions that the rights of citizens to approach the Constitutional Court via the requests on this type of cases related to a constitutionality of the law. It is one of the form for fair judicial proceedings. And the court mentioned that the decision of the judicial dispute without the preliminary decision of the Constitutional Court means that this is not peculiar to the general courts. It was always said that general judge is the first constitutional judge, as this ordinary judge at the first stage saw certain unconstitutionality in the applied law. In this regard, there are a number of conditions that can be used to request the solving this case of unconstitutionality. The procedure includes two stages. The first one is the judicial one, when it is mentioned preliminary and within the judicial proceeding, a request is submitted on this exclusive case of unconstitutionality, and the judge takes the decision that may end up with the approach to Constitutional Court. And the second stage is the constitutional control itself in case of these unconstitutionality cases, which is done by the Constitutional Court. There is a question: who is the subject or is entitled to demand the solution and consideration of this unconstitutionality case? In case of Kazakhstani issue here, the exclusive cases exceptional cases can be stated by the courts, except for the court that at its initiative can refer to Constitutional Court. Also, this motion can be submitted by the parties, also by the representatives of the parties whose rights and interests are infringed upon because of the unconstitutionality of certain norms of certain law. I would like to mention that 99% of all requests are coming from the parties of the processes and not from the judges. Judges apply rarely to Constitutional Court, usually on fundamental questions, for example, like procedure of the use of the preliminary arrest or things like this. But in general, this is done by the litigants. And one more moment I would like to specify, which is also important in terms of the legal provisions in Kazakhstan. What acts are considered as the objects for this exceptional cases of unconstitutionality? We have a strict list of the acts defined by the Constitution, by the law. These are the laws, parliament laws, presidential decrees, and also governmental decrees. What is important to mention here? There should be the strict division between the competences for consideration. It should be different from the law in order to avoid the confusion with regard to other courts. For example, administrative courts. There are acts that are issued either by the parliaments or the governments, let's say, for example, of individual nature, it's not the jurisdiction of constitutional courts, and it's their jurisdiction falls under the ordinary courts. Here, I would like to focus your attention on a very important aspect regarding the conditions for solving these exceptional cases of unconstitutionality. The judge is not entitled on the groundness of the request or constitutionality of the challenged norms. The judge doesn't have a right somehow to sense this request. He or she simply automatically refers them to the courts, but just checks 4 main requirements which are of, let's say, of formal nature. The judge defines whether the object of request is related to the category of acts that can be challenged, as there can be a case that the party may request the constitutional review of the act, which is the jurisdiction of the other court. And the second element is important. This system is banned in our case in order not to confuse the systems and in order not to turn the review into individual complaint. It's very important for the party or for the judge to make sure that certain provision is applied in this particular dispute, which is being considered. It should be clearly stated that the party that has the right, to submit this request, submits this request in reality. And the last, if the judge checks the previous judgments of constitutional courts that can resolve this issue, like in order to avoid the repetitions or repeated hearings. So, and the court has a right also to refuse to the parties to consider this exceptional case of unconstitutionality. So, but in general, the judges do not have this right to refuse to accept this type of request, except for the cases that I have mentioned before. As for the requests submitted to the constitutional courts, they are submitted directly to constitutional courts or by the judges that here dealt with. The party that requests this review of constitutionality is not entitled to directly approach the constitutional court. It is done in order not to confuse these two types of requests to this type of courts. And our colleague, Mr. Bahut, also mentioned this important point regarding the fact what is happening with the process of cases, with the proceedings in case if the request is submitted to Constitutional Court, starting from the moment of judgment on the decision on this submission of the request on this on the unconstitutionality review, and until the decision is made. The proceeding is not stopped, but it's not finished too. So it goes on until the decision of the Constitutional Court. But we always had this question. The court somehow should find a balance. On one side, the interests of the party and the interests of the justice in general, that to avoid the application of unconstitutional norms, and obviously the speed of proceedings on the cases, as usually parties would like to have all these proceedings done quicker. And the Constitutional Court decides that in this situation, the judge should pursue this the review of constitutionality of norms, and can postpone the proceeding only for the periods where it is solved whether the norm is unconstitutional. But in practice, it's done, it looks differently. As usually, these cases are considered quite quickly. We have the procedure of acceptability in the Constitutional Court, and during 2 weeks maximum, the court decides this decision whether this request is submitted for consideration, and then the court will take required measures, or it is this request is rejected, and then the proceedings on the case continue. As for the consideration process in the Constitutional Court itself, as I have mentioned, the first stage is admissibility. In this case, it's not the court itself, but it's administrative office that works with these documents. And then one judge considers and decides whether it is acceptable or not, whether there is some substantive nature or not, as quite often people are approached by mistake. And if it is acceptable, then the same day the relevant notification is sent to the ordinary courts. Then there is a preparation process for public hearing. And here there is an important moment. The court, at its discretion, and usually we do this procedure, sends different questions to the parties. These are specifying questions regarding the referral itself, as quite often the issues that are sent from the courts are not related to abstract matters of the law. They are related usually to particular judicial practice. And in this case, the court has this practice of making this type of decisions. For example, constitutional norm of the law is constitutional only provided that the ordinary courts apply it in the following manner. And this helps us to influence the implementation of constitutional principles in the ordinary courts. As for the consideration of the case on the substance, quite often these are public hearings in 90% of cases. And Constitutional Court takes this specific decision on this procedure, and attorneys deliver their speeches for the parties not to be involved, as this is a legal dispute, and we think that the person that approaches the Constitutional Court should have certain legal practice, knowledge, skills, and so on. Therefore, there can be two parties, either the judge who approached the Constitutional Court himself or herself, or the party, litigant. In order to stick to time, I would like to talk about the effects. There were really huge effects achieved. The first one we felt was depolitization of Constitutional Court. We discussed this a lot, as the society also requires that from us. If 90% or 100% of requests are coming from parliament, prime minister or president, then of course this will be quite to political agenda. On the other side, if we also exclude somehow these ordinary courts from the jurisprudence of Constitutional Court because of this important constitutional principle, then there will be just a kind of a doctrine material for the judge, but it will not be a material that will be applied in practice, in judicial practice, on a daily basis, which is quite important. So the first effect reached was making Constitutional Court unpolitical, and the majority of cases considered by Constitutional Courts are coming from the courts. That was the first effect. Second, we postponed the question of direct access of citizens, as we gave a good tool that can lay the ground when the individual complaint will be introduced. This is a matter of time. But before we introduce this process, we solved this issue of having access to constitutional justice via the ordinary courts. Maybe certain proceedings or procedural moments should be mentioned, but they're not that important, as they were discussed already. The court always had a proactive role. The court always was interested in getting this type of requests from lower courts. I will state this differently, like ordinary courts are kind of employers of the constitutional court. Like there are many examples of constitutional courts that consider 10 to 20 requests on an annual basis coming from political environments. And then there is absence of requests on material or procedural nature. And in this case, the court deprives itself from this opportunity to act as the protector of human rights and freedoms. And on the other side, the court doesn't have the opportunity to influence all the processes of jurisprudence in the country. So talking about the proactive role, the court developed all required forms for the documents, and they're available on the website of the ordinary courts. So there is these forms are just for information, and parties just by simply filling in these forms, for them it's quite easy to follow the procedure without violating this procedure, without missing any details. And I would like to wish everyone success in pursuing this intent to improve the access to constitutional justice, and I'm confident that with our common efforts, you will succeed. Thank you very much. Thank you, Mr. Tanasi. With a great interest, we listened to your report, to your speech, and also preliminary, we have thoroughly studied the decisions of Constitutional Court of Moldova on this matter, and many provisions are important for us. I would like to pass the floor to the Vice Minister of Justice of the Republic of Kazakhstan, Ms. Natalia Vissarionovna Pan. Distinguished participants of the forum, I would like to use this opportunity, and I would like to congratulate Natalia Vissarionovna with her birthday, and I wish you success. Please, the floor is yours.
Thank you so much, Mr. Mami, and dear participants of the International Roundtable. Let me welcome you at this roundtable, and let me express our sincere gratitude for the invitation on behalf of the Ministry of Justice. The issues considered at this roundtable are related to the law enforcement practices under Article 78 of the Constitution of Kazakhstan, and the topic of today's roundtable, the referral of cases to the Constitutional Council by ordinary courts, is highly relevant. In May of 2020, the government provided its conclusions to the regarding the law on making changes and supplements to some legal acts of Kazakhstan regarding the referrals to the courts, which was initiated by the parliamentarians from Majlis. And the main goals of this draft law were determined as the legislative regulation of mechanisms of submission and consideration of appeals to the Constitutional Court. And particularly, the draft law suggested clarifying the order of decision-making by the courts on about accepting the normative legal act as unconstitutional, are establishing the basis for the satisfaction of the appeals that were received by the Constitutional Court. And this draft law also showed that the General Prosecutor's Office and the Supreme Court are a bit concerned because of the following. The implementation of the norms of the draft law can deprive a judge of its right for independent assessment and resolution of appeals. And when the courts consider such issues as whether the appeal is within the competences of the Supreme Court, whether the constitutionality of the appeal was inspected or checked, or the draft law of the draft law presupposes the mechanism of providing the or sending the appeals to the Constitutional Court may facilitate the abuse of power by the parties, and the courts may be used for the scandalization purposes or for the purposes of the creation of social tension. Given the current situation, this draft law requires additional discussion and consideration. Dear participants of the roundtable, let me express my hope that as a result of today's roundtable, we will be able to come up with most optimal solutions to this topic or issues. I wish the fruitful work to all the participants of the roundtable. Thank you for your attention. Thank you very much, Natalia Vissarionovna. You're right when you say that the Ministry of Justice coordinated this work on the draft law last year, and those issues that you have mentioned in your speech, given all the ideas and proposals voiced today, will be lifted. Hopefully, we will be able to find the logical conclusion of this draft law. Hopefully, this will happen. Thank you so much. Next floor goes to the member of the Presidium of the Republican Board of Advocates, Madam Sabirina.
Ayjan Jumash kızı, the floor is yours, please. Could you please unmute your mic? Miss Sabirina, could you please unmute your mic? That's okay. Yeah. Now we can hear, yes. Yeah, we can hear you. Thank you very much, Kairat Abdrazakovich. Distinguished participants of the round table. First of all, I would like to thank organizers for invitation and submission for discussion. The questions of considering by the Constitutional Council the request from the ordinary courts. The representatives of attorney community participated in the working group on the improvements of criminal judicial proceedings created by the General Prosecutor's Office on certain, in general, they are supported by the attorneys community, as there is a requirement on having this requirements to the form and the content of motions on the request to constitutional councils. According to the current legislation, the grounds for approaching the Constitutional Council should be the fact that the judge finds that certain acts infringe upon the rights and freedoms of certain people. Unfortunately, in practice, the courts do not approach Constitutional Council. They decide themselves whether these acts infringe upon human rights and freedoms, or whether this act should be applied or not. And quite often, they refuse to accept the motion of the litigants. The confirmation is given through the statistical data that were mentioned by the previous speakers. Over the 24 years of the Constitutional Council considered only 71 requests of the courts. Of them, on 31, there were refusals. And in fact, only 40 were considered. This is a really small number of cases, and it's not in line with the real level of the violation of Kazakhstani people's rights. In reality, we should establish a system for protection of constitutional rights of our citizens. Unfortunately, there is no separate column in statistical reports of attorneys that will account the number of motions submitted to the courts. And this data is not available also in the Supreme Court. About the facts of the refusal of the courts in meeting the motions, this information can learn from mass media, where attorneys quite actively share information about the process of considering motions by the attorneys. The opportunity to check the initiative of the courts, the constitutionality of the law that came into force is quite important, as only in these cases of the mandatory approach to Constitutional Council, in case of any doubts, we can guarantee the real protection of constitutional rights and freedoms of citizens and individuals. The practice shows that quite often defects and deficiencies in the content of the laws, usually they are revealed in practice in the process of the implementation, and the timely acknowledgement of such laws of the normative legal acts as unconstitutional and controversial to the Constitution will entail the real protection of human rights and freedoms. I would like to hope that the amendments proposed by the Constitutional Council will ensure the real practical opportunity for the protection of the constitutional rights and freedoms in case of the infringements. Unfortunately, currently it's quite problematic. Thank you for your attention. Thank you very much. Ms. Sabirina, yes, in the number of countries, the role of attorneys in the constitutional proceedings is quite important. And yesterday, during the session of the National Council of the Public Trust, the head of state, Mr. Tokayev, repeatedly mentioned that we need to reinforce the rights of attorneys in our country. And therefore, this proposal coming from the Constitutional Council does not enlarge the competence of Constitutional Council. Everything stays as it was before. Our draft law reinforces the rights of the parties of the proceedings, judges and attorneys. So please take this into account, as you have mentioned that the competence of Constitutional Council is reinforced. So the next floor, I would like to pass to our guest, the head of the Public Law Section, Legal Science Department, La Sapienza University, substitute member of the Venice Commission, Mr. Cesare Pinelli. Mr. Pinelli, please, the floor is yours.
Thank you very much. I will speak about the Italian model concerning referral of cases to the Constitutional Council by ordinary courts. Under Italian law, the question of constitutionality may be raised either directly by the state and the region with respect to a violation of their respective legislative competences, or incidenter, namely parenthetically by a judge in the course of a judicial scrutiny. Most part of the court's work consists in scrutinizing questions issued by a judge. For issuing a question before the court, the judge has to meet 3 requirements. First, he must be the judge of a judicial controversy. Second, the question must be relevant for the case. And third, the question must appear not clearly unfounded to the judge. Let us examine these 3 requirements. The question must be raised by the judge of a judicial controversy either directly or ex officio, or indirectly by one of the parties, including the public prosecutor, that may ask the judge to raise the question before the Constitutional Court. This means that the parties cannot file their claim directly with the Constitutional Court. There must be instead a judge, subjective requirement, and a judicial case, objective requirement. The judge may be part of the judiciary power or recognized as such by the court in certain cases, provided that it is considered a third party vis-à-vis the parties of the controversy with the aim of raising the question before the court. This is why he is called judge a quo, Latin word that means from which, a quo. In turn, the judicial case may not be a controversy between 2 parties, but also a control procedure. In that case, what it counts is the neutral and objective role of the judge. Second, the question must be relevant for the case, which means that the provision that is object of the claim is essential for the judge to deliver a decision in a concrete case. If it can be solved without applying the disputed provision, the question is deemed irrelevant, even if the provision might clearly violate the Constitution. The fact that the question must be relevant to the case exhibits thus clearly the incidental nature of the access before the court, namely that access can be realized only during a judicial controversy. Third, the question must appear not clearly unfounded to the judge. It means that the judge carries out a sort of preliminary review of the provision that he is likely to enforce in the case, regarding whether the question with unconstitutionality is or is not clearly unfounded. In the former case, he will simply continue his judgment and enforce the provision. If instead he has the slightest doubt as to whether the provision is in pursuance of the Constitution, he will deem the question as not clearly unfounded and will then suspend the case and refer it to the Constitutional Court. So the judge does not have to be convinced that the law is unconstitutional. In that case, he would not need to put the question before the court and would convert himself into a constitutional judge, with the effect of contradicting the whole system of constitutional justice, which is founded on a sole and specialized court. Furthermore, the order with which the judge a quo suspends the case and refers the question to the court must contain the judge's reason for taking this decision and should indicate also the constitutional provision that he presumes has been violated, the state of law that is alleged to be unconstitutional. The account above reported might have demonstrated that access to the constitutional review requirements, as well as the judgment's parameter and object, are previously established by the Constitution, or at least by law, but also that much room is left to the court's interpretation of such requirements and conditions. This room is crucial for understanding the effective functioning of the mechanism, which creates a triangle between ordinary judges entrusted with the task of submitting the question of constitutionality to the court, Parliament, whose acts are subjected to constitutional scrutiny, and the court itself. The latter's interpretive power appears crucial for that end, because it is upon the court to decide to what extent its own scrutiny can be opened, one, to judges different from those pertaining to the judicial power, in such cases, two, through a control over the relevance of a certain question. 3, through a control over whether a certain question is clearly unfounded. 4, with respect to the object of the judgment, in particular to normative acts whose possibility to fall under the label an act having statutory effect, as the Constitution says, is doubtful. And 5, with respect to the parameter of the judgment, in particular to norms whose equivalence with the Constitution is disputable. Clearly, the more the court interprets broadly these elements, the more it increases its generosity in opening access to scrutiny and vice versa. The court tools play a crucial role in light of the very premises of the system, where the court's role is related both to the judiciary and to parliament due to constitutional and legislative provisions, but also to the devices that are from time to time needed beyond the legal text for avoiding dangerous conflicts among these institutions and enhancing their mutual cooperation. In other words, for maintaining the cooperative, the triangle. Thank you very much.
Thank you, Mr. Pinelli, for telling us about the experience of the Italian courts, because we are quite interested in your experience and we wish you the best of luck in your future work. Dear colleagues, let us now give the floor to our Kazakh colleagues. Next floor goes to the professor of Gumilov Eurasian National University, Yermek Abdrasulov. Please, Mr. Abdrasulov, the floor is yours.
Thank you, distinguished participants of the round table, distinguished Mr. President. The issues of improvement, the mechanism to protection of human rights and ensuring such legal grounds that all the requests and motions of the citizens to state bodies, including judicial authorities and constitutional control body, would be heard by the state authority and resolved in full, are quite topical today and very important. Constitutional and legal mechanisms for implementation of the norms of the Constitution on the protection of human rights and freedoms is ensured both through the direct normative regulation of relevant relations and also through the legal position of the Constitutional Council expressed in its normative documents that, on one side, take into account the imperative nature of certain constitutional provisions that deal with the competence of certain state body, but on the other side, that show the connection in the activity of any state body that is and it's related to constitutional principles mentioned in paragraph 1, Article 1, and paragraph 2 of Article 12 of the Constitution. And this aspect, I think, solving the question on the compliance of the laws and other legal acts to the Constitution are defined in the Constitution of our country as imperative one, and this competence is with the Constitutional Council according to the group of norms of the Constitution that enshrines and entrusts these powers to the constitutional control body. These are Articles 73, 74, 75, and 78 of the Constitution. At the same time, we have the mechanism for implementation of this competence that ensures this request submission to Constitutional Council where that doesn't have citizens. Probably the lawmaker thought that following these fundamental principles of the Constitution, the application of the laws and other legal acts, a priori, it will be defined by the human rights and freedoms, and that the courts in the court of litigation will have an opportunity to see the incompliance of the laws or other legal acts with the Constitution based not only on their own conclusions, but also the standpoints of the litigants. in practice, we get the situation that courts practically do not meet the motions of the litigants about the requests submitted to constitutional councils. Thus, in fact, they got this powers on the final decision, judgments on the issues on the compliance of the laws and other legal acts with the constitution in case of the doubts by the countries. And this infringes upon human rights and freedoms. For example, in 2019, the law, we had the case when the law envisaged that the cost of the land plot that is taken for state needs is transferred to the owner on the, according to the civil legal deal or at the decision of the court is defined in the according to the amount of the value indicated in the agreement or in the judgments of the court, but does not exceeding the market value. And the citizens in the course of litigations repeatedly stated in their motions to the court, saying that these norms of the law were controversial, not in line with paragraph 3 of Article 26 of the Constitution that states that the forced taking of the property for state needs in exclusive cases envisaged by the laws can be done only in case of the reimbursement of its equal value. Such motions of the parties were rejected by the courts. For example, in 2014, according to the report of independent evaluation company, there was a real market value of one disputed land plot at that moment, which was equal to 6,805,000 tenge. And the owner, in fact, received the compensation, which was 4 times less than the market value of this property that was taken away. And there are many cases like this. So what ways we have in order to ensure that the citizens' opinion will be heard? First, it's introducing the changes to the Constitution and expanding the circle of subjects of the requests in the relevant sections, and submitting amendments of Criminal Procedural Code, Civil Procedural Code, Administrative Procedural Code of the Republic of Kazakhstan. There are proposals like this, and they support this opportunity. And for example, paragraph 5 of subparagraph 5 of paragraph 4 of Article 195 of the submitted draft CPC states that one of the grounds for refusal in meeting the motion should be the lack of the grounded enough sufficient data that indicates the infringement and the violation by the law and of the rights and freedoms fixed in the Constitution. And the fact that there will be statement used that the party doesn't have sufficient data that indicate the infringement by the law or legal acts, the constitutional rights and freedoms of citizens and human beings. And so we think that there can be used this type of statements. And plus the paragraph 5 of item 3 of Article 195 of this draft document gives the right to the court to identify whether the law infringes this type of constitutional rights and freedoms. In fact, this type of right of the court can eliminate all the efforts of the litigants to be heard in the constitutional control body. And I think that these two provisions will further contribute to the situation when the court will practically assume all the powers on exclusive cases identifying the constitutionality of the laws or certain legal acts. And third, there is a good experience of Moldova went through the Constitutional Court decision of Moldova on interpretation of the Constitution. There was developed the legal position that expanded the number of subjects that can refer to Constitutional Court by including their courts and not only this higher judicial chamber as it is indicated in the Constitution. Besides, these subjects can be actually included also with the litigants. as the request regarding the exclusive case on unconstitutionality can be submitted to the court, general court, by any litigant representative, and the judge is not entitled to state on the groundness of this type of request or constitutionality of the challenged provisions, and should limit itself to checking these formal requirements, as it was mentioned by the previous speaker from Moldova. And what is the revolutionary meaning of this is that the Constitutional Court identified and determined the legal position on the expediency and necessity for the supervision and interference of the Constitutional Court in the process of the application of the norms by the courts, constitutionality of which is doubted. And this basis, they identified but the provision that supplements the actual constitution without changing its initial text, and as identified that the judges of the general court do not have the rights to refuse to accept requests, motions from the litigants regarding the referrals to Constitutional Court. The only drawback in this case, I think that the general courts, in fact, do not have the right to express their standpoints on the issues of constitutionality of legal acts submitted by the litigants. And by that, we infringe the independence of the representatives of judiciary from ordinary courts. And also the mechanisms are not proposed that will prevent the cases of abuse by the litigants of this type of rights. What is the acceptable way in the current conditions, given the fact of the experience faced by the foreign countries? So I propose the following measures on the improvements of the legal regulation of the relevant relations that open for the citizens indirect access to Constitutional Council of the Republic of Kazakhstan. It is possible to do first through official interpretation of Article 78 of the Constitution with explanation of this phrase if the court decides that, to our opinion, includes also the position of the litigants regarding the constitutionality of the law or other legal acts. Based on the legal positions of the Constitutional Council, we can introduce this type of changes to legal acts. Secondly, through initiating changes in the procedural laws and other legal acts, we think that stemming from these basic principles of Constitution and the state legal policy of the Republic, so defining factors during the improvements of the Institute of Referral to Constitutional Council should be the norms, principles of Constitution about the fact that the Republic of Kazakhstan states itself as democratic, secular, legal, and social state, the supreme values of which are individual, his or her life, freedoms, and rights, and that they define the content and application of laws and other legal acts. Moreover, the concept of the hearing, listening state requires the embodiment into the legislative regulation, the norms about the fact that the body of constitutional control should listen not only to the position of the courts regarding the constitutionality of the laws, but also to the ordinary citizens. In this case, we think that it's possible to consider the following procedures in the legal acts. The judicially can submit the requests on constitutionality of the laws and other legal acts to Constitutional Council at its own initiative in the course of case proceedings. And second, the court also is obliged to submit the request at the motion of the litigants if the court agrees with the arguments of the parties about these requirements of the approach to Constitutional Council. The third, the court, if disagrees with the arguments of the litigants on the unconstitutionality of the law or other legal acts, is obliged to prepare to draft motivated, grounded conclusion, opinion on its standpoint and submit it to for information, both positions to Constitutional Council for information. Proposal number 4, Constitutional Council, during preliminary study with different positions, agrees with the court's arguments, then returns documents back to the court. So these are my proposals regarding the topic that we're discussing today. Thank you very much, Mr. Abdrasulov. We will use your proposals in our work and we will discuss them. And I would like to pass the floor to the chief researcher of the Department of Constitutional Administrative Legislation, Public Administration of the Institute of Legislation, Legal Information of the Republic of Kazakhstan, Mr. Ali Pasha Karayev.
Thank you very much for the floor. Good afternoon, dear participants of the roundtable. Let me, first of all, thank the Constitutional Council for the invitation and the opportunity to express some thoughts regarding the institution of indirect constitutional referral and increasing efficiency of interaction of courts and the Constitutional Council. In the context of the formation of a legal democratic state in Kazakhstan, legal guarantees for the protection of individual rights and freedoms play a special role. And in this regard, the global experience shows that one of the most important human rights instruments in this regard is the institution of constitutional review, the effective functioning of which ensures to protect the rights and freedoms of the citizens. In Kazakhstan, with the adoption of the constitution in 1995, the institutional review model has changed and the Constitutional Court was replaced by the Constitutional Council. As we all know, according to the older model of the constitutional control, there used to be the institute of the direct constitutional referral when the citizens could directly appeal to the Constitutional Court to get the protection of their rights and freedoms. Whereas nowadays the model is quite different and there are a lot of mechanisms related to the protection of human rights and freedoms which provided possibility of an indirect referral to the Constitutional Council. That's when the citizens can go to the Constitutional Council through the courts. It shall be noted that until recently, indeed, the courts used to be the only subjects for referral, but within the framework of the constitutional reform from 2017, this right was provided to the head of state, the president of the republic, and under Article 44, in case the existing law that was already enforced or any kind of legal act violates the rights and freedoms of citizens for the purposes of ensuring national security or territorial integrity, the president is also entitled to appeal. But since these practices have not been formulated completely yet, today we're talking about the referral by courts only. Of course, there are some advantages of the subsequent control because the Constitutional Council does not interfere with the legislative activity of the parliament, but given the experience of applying different laws and regulations, there is a possibility for making adjustments. There is a possibility for making some laws and regulations aligned with the practices. And if the law is against the real practices, if the law is against life, these laws shall be changed or adapted to reality. So a lot of speakers today mentioned this, the existing order under which the courts are obliged to go to the Constitutional Council in case there are some doubts. Let's say they're not obliged to go to the council, they are obliged to suspend the process and then go to the Constitutional Council. Well, this order is not that effective because it fully depends on the discretion of a judge. And we realize that the judicial discretion is a part of the law enforcement practices and the administrative, civilian, or criminal procedures will not take place without the judicial discretion. Today, a lot of speakers said that about the number of referrals. Someone mentioned 71 referrals, but one cannot say that this field does not have any problems. That is why people do not go to courts. Actually, there is an issue, and maybe that's related to the institute of the filing of referrals or complaints. And maybe this is something that we need to talk about. As regards the proposals that have been developed by the Constitutional Council in order to make the work of courts more active, or maybe by providing a right to citizens to appeal in an indirect manner through the Constitutional Council. In my opinion, Until now, the procedural law did not prohibit filing appeals. The procedural law does not have any appeals at all. There are some guidelines, and in principle, it was possible to appeal. But since there is a suggestion that we highlight the appeals or referrals, maybe we should mention it as the possibility for referring or for referencing the courts through the council, because we need to clearly state the issues of provision of protection of the rights and freedoms of the citizens on a higher level. So this problem is highly relevant. I totally support discussing this topic more often, and I always say that it's better for the citizens to have a direct reference to courts. But since the system is quite different, we are talking about the system of indirect references. What are the risks, in my opinion? Of course, I think that we shouldn't be guided by these risks only, and these risks shall not form a very strong argument for not considering such a right for direct referencing. What are the possible issues and how can we mitigate the issues? First of all, we need to clearly determine who is going to be provided with this right to appeal. Are these just the citizens? Are these individuals or legal entities or maybe other parties to the process, like prosecutors, lawyers, or other individuals, stakeholders, the list of which may go on and on? We need to clearly determine this because that will determine the number of cases and the number of references and appeals. Also, we need to, well, given the fact that we provide this right to the citizens, let's say to all the parties to the process, we need to be prepared, or the judiciary, first of all, needs to be prepared to process the flow of references and complaints because they are going to go up. And citizens or any other parties to the process will use the references, referrals, and appeals as their last mean of resort. And they will try to convince a judge that some norms are infringing on their rights and freedoms. For instance, if a person is being deprived of his property, he may consider it as a violation of his rights and freedoms. Or, as Yermek Bayahmetovich mentioned, if someone gets a smaller remuneration, he may consider it as the violation of his constitutional rights. So a citizen will use this opportunity. I'm not saying that it's a bad thing. That's actually really good. But we need to think about the consequences because this can result in the fact that the courts will be overloaded. So in this regard, we need to first of all think about whether or not the judicial system is prepared. Maybe the Constitutional Council and courts shall attend some webinars, trainings to learn more about these processes of filing referrals or appeals, because that takes a lot of time, a lot of efforts, and a lot of knowledge, theoretical knowledge or academic knowledge, because the processes of learning norms in this case take time, and it is really difficult for. It's a very difficult thinking process. Recently, I talked to one of the judges and I asked why these referrals are so rare. And you know what she said? She said that the courts, the judges are overloaded. For instance, there are more than 50 cases per judge, and it's almost impossible to spend time on, filing complaints or formulating complaints and referrals, because that's a very difficult thinking process, and it's related to understanding of rights and constitutional norms. I don't think that every person can handle this. So this judge that I was talking to said that it's sometimes easier to apply the norms rather than to understand what it means in order to justify to the Constitutional Council its constitutionality. Well, this problem needs to be resolved. The Institute of Indirect Constitutional Referrals needs to be revived. And for instance, when a judge is considering a case and he has a certain discretion, let's say he has several behavioral options, very frequently a judge prefers to decline. But in fact, A judge, according to the Constitution, refers to constitutional norms, and he is entitled to make a decision or a ruling based on the constitutional norms by applying the principle of the validity of constitutional norms. But that does not really happen. Maybe the second option will be more preferable for a citizen when a judge agrees with the arguments of a citizen and accepts his appeal or makes some adjustments to his appeal, because it's not a citizen that is the subject of appeal. This is the judge who is the subject of appeal, and depending on the quality of an appeal, one can assess the capacity or capabilities of a judge. For instance, whether or not his writing skills are okay, or whether or not his arguments are justified. And there is a third option when a judge declines an appeal. And it was fairly noted by previous speakers that these norms are quite diffuse because we need to clearly define what kinds of case, in which kinds of cases a judge is entitled to decline the appeal. There must be some statement that can convince a citizen that his appeal was duly declined. And there is one more problem that mostly relates to the norm of Article 78 that says about the obligations of a judge. And here I would like to quote Kairat Abdrazakovich Mami. When he was the chairperson of the Supreme Court, he paid attention to these issues. And this is what he says, and I quote, maybe it's a high time for us to look at the constitutional control measures, just like in Russia, and consider the as rights, not as obligations of judges, because some legal acts infringe on the rights and freedoms of an individual. And according to the professor, this will increase the authority of courts and and their independence, and this will facilitate the broader use of constitutional norms. Indeed, when we use the word obligation, in my opinion, this word means that there is something that a judge must do. Nevertheless, we understand that the judiciary is based on the principle of autonomy and independence, and are not. Does it mean that we are undermining this principle or not? There is another set of questions which, in my opinion, is highly relevant, and it requires some resolving or resolutions. And this question is related to legal acts which can be a subject of consideration by the Constitutional Council. Of course, Article 78 of the Constitution is quite general, and it does not list, well, just like in Moldova, it does not list specific arguments which can be justified or declined. We don't have that. We have laws and other legal acts, and there are a great variety of them. There is the experience of the Constitutional Council of France. Our speakers mentioned that in 10 years, there were thousands of appeals or referrals, whereas in France, when, for instance, a person goes to the government council, only the laws can be the subject of consideration by the Constitutional Council. As for other legal acts, they are mostly covered by the administrative jurisdiction. Maybe it makes more sense for us to somehow delineate them. For instance, if we try to interpret better the Article 78, and if we try to do something at the Constitutional Council without violating the norms of the Constitution, maybe this will take some word-for-word adjustment of Article 78 of the Constitution. This is the problem that needs to be resolved, especially with the adoption of the Administrative and Procedural Code. This part of the issues may be lifted, or maybe it makes more sense to say that some laws could be considered by the Constitutional Council, and when it comes to other legal acts, these legal acts could be considered by the Supreme Court to, let's say, determine their constitutionality. Maybe it would take off more burden from the Constitutional Council. And maybe in some way, this will help alleviate load off the courts, because both courts and the Constitutional Council are overloaded, and maybe by creating some structural divisions or making some changes or creating some unit for accepting the complaint, we could reduce this burden. I think that the proposal is quite timely, and this problem is somewhat related to the activization of modernization, let's say, of the Institute of Indirect Constitutional Complaints. We need to provide a new impetus to this issue, especially now when I think we are implementing successfully the concept of the listening state. Thank you for your attention. Thank you, Mr. Ali Pasha Karayev. Please feel free to submit your proposals. We'll take them into consideration. Next floor for welcoming remarks now goes to the Head of Cooperation of the European Union Delegation in Kazakhstan, Mr. Johannes Stenbeck-Madsen. Please, the floor is yours. Mr. Madsen.
Thank you very much. I hope you can hear me. First of all, I would like to thank the Constitutional Council of the Republic of Kazakhstan and the Venice Commission for having organized this roundtable and for offering me the opportunity to say a few closing remarks, as it will be now, on behalf of the European Union delegation to Kazakhstan. The question, as we have heard during the day, concerning individual access to constitutional justice plays a critical role in the process of strengthening mechanisms for the protection of human rights. And the improvement of the legal framework for the Constitutional Council of Kazakhstan is an important step in this direction. The European Union supports this development, and we hope it will contribute to a more efficient functioning of the state institutions in line with international standards and best practices. As you may recall, the European Union launched the Central Asia Rule of Law program in 2019. The program, which is implemented by our trusted partner, the Council of Europe, aimed to share international standards and practices in the area of the rule of law with our Central Asian partner countries. The European Union and the Council of Europe share the values of democracy, rule of law, and human rights, and the two organizations are working hand in hand to uphold and protect these values around the world. The Venice Commission plays an important role in the implementation of the Central Asia Rule of Law program. The Venice Commission has unique technical expertise, which is tremendously useful in the field of constitutional reform, analysis of existing legislation, producing recommendations on how to improve regulatory frameworks, and the overall functioning of state institutions and the judiciary. The fact that the Kazakh authorities approached the Venice Commission for a legal opinion demonstrates that there is trust and a strong will for high-level cooperation between Kazakhstan and the Venice Commission. I can only commend the willingness of the Kazakh authorities to benefit from the expertise of the Commission and other countries. It can contribute significantly to develop modern legislation in Kazakhstan, which would reflect best international. In conclusion, I would like to say that, or emphasize that the European Union supports this process, because it also contributes to building a more open and democratic society in Kazakhstan and the other based on respect of the rule of law and democracy. Ahmed.
Вам спасибо.
Thank you very much, Mr. Madsen. I wish you to successfully implement the next program of the European Union and the Council of Europe on the rule of law in Kazakhstan. Distinguished participants of the round table, we have finished with our reports from the speakers. Now I'd like to open the discussion. If you have any questions, so please, the time limit is the following: 1 minute for question and 2 minutes for comments or answers. So is anyone willing to express the comments or questions? I see that Mr. Rogov wants to express his opinion. He is the former chairman of Constitutional Council of the Republic of Kazakhstan. Thank you very much. Distinguished Kairat Abdurazakovich, distinguished Mr. Gianni Bukike, I would like to thank you for inviting me to this interesting event. The topic is quite relevant, and I learned a lot, and I really enjoyed the level of the discussion that we had today. So coming to the main topic, of course, for us, the experience of other countries is quite important, and it should be mentioned that the right of a citizen to approach the constitutional control body is envisaged in the constitution and other legal acts of many countries. And by the way, Kazakhstan also has such an experience, a constitutional court that was there until 1995, had a right to consider individual complaints. And I saw among the participants the former judges of this constitutional court, Mr. Malinovsky. And they will correct me if I'm wrong, that we can state, based on that experience, both positive and negative moments. The positive one was that citizens had real access to constitutional justice. The negative moments were that the number of subjects that were able to approach was broad, and not just too broad, but very much broad, as there was no restriction that only in case if the dispute of the citizen is considered in the court, the citizen, it was just enough for the citizen to state that certain law violates his or her constitutional rights, and formally he or she had a right to approach the constitutional court. The drawback was that there was so many applications. They were called claims back then. There were hundreds, even thousands of such type of requests that were not resolved in reality and just led to the disappointment of people with the work of this body. But when the new constitution was adopted, the right to individual complaint was not taken into account. And here it was quite fairly stated that indirectly today citizens have a right to approach the constitutional control bodies via the courts. During the first years of Constitutional Council existence, I cannot say that we had a lot of requests, but the institute worked quite effectively. Like there were examples given here about 70 applications like this, but the majority of them was submitted during the first years of the work of Constitutional Council. What was the reason for the reduction, a sudden reduction of the referrals of judges to Constitutional Council? It's difficult to answer. I think there are both objective and subjective factors. Of course, presumption of constitutionality of any law is valid, but doubts can also be there with the judge and parties to the proceedings. Obviously, in the long term, we would like during the next constitutional reform, we would like the right to be directly included, the right to be able to approach in order to check the constitutionality of certain law or legal acts, maybe just the law. I agree here with the speakers but provided that the problem that this particular citizen faced was not resolved previously by the relevant court. But today, as far as I know, we do not plan to have any reforms like this. Therefore, it seems to me that the path proposed by the Constitutional Council in order to activate the institute of the referrals of the courts to the Constitutional Council is correct. And repeatedly, Constitutional Council proposed to formalize this process of considering by the courts of motions regarding the review of constitutionality of certain law or legal act. And arguments, those who were against this type of changes, of course, they should be taken into account. Yes, there are concerns that the judicial proceedings will be delayed, but if of one side we have such constitutional values like human rights and the justice, then probably we should make the most important conclusion that the worst will be not the delay of the judicial process, but it will be if the certain court decides based or takes judgment based on unconstitutional law or legal acts. This is where constitutional order, even constitutional rights and freedoms and justice that use unconstitutional norm will suffer. And if there are any grounds for doubts, then in the legislation, an effective mechanism should be envisaged that would provide for the opportunity to meet the rights of the citizens for applying with regard to the citizen constitutional norms. And it seems to me that, well, unfortunately, I haven't seen the draft law that is discussed here, but from certain comments, I understood the overall situation. If I understood it correctly, the point is that the question was considered by the court based on the motion of certain party, but the refusal to refer to Constitutional Council, as it seems to me, should be necessarily grounded by the judge. The judge cannot just simply state that I decline. No, the judge should give their arguments why he or she thinks that the referral to Constitutional Council is inexpedient. And further higher courts or bodies, they may or not even may, they are obliged to consider the judgments at the essence and also the judgments on regarding the refusal on the referral to Constitutional Council. As with all due respect to the judge, as any human being, can make mistakes. Therefore, the high-level courts or authorities should have an opportunity to check this. One of the options can be more radical proposal to consider, like the case is considered in the first-level court. The judge refused in the course of these proceedings to refer to Constitutional Council, and the party, without waiting for the judgments of the first-level court, should be able to approach the Court of Appeal or other courts with a request to cancel this decision of the judge on the refusal to refer. The concerns about the fact that this will delay the process, I think it's not really grounded. As for the consideration, the fact that the complaint is grounded or ungrounded regarding the constitutionality, there is no need to study the criminal case or civil case. It is just enough to know the arguments, as we are not talking about the assessment of the actual facts of the case, but we are talking about the evaluation of the law, which is applied with regard to this particular fact, and that can be applied also to other things. So here, there can be found ways on how to do that. And Murat Muratovich quite fairly stated that certain doubts with regard to the possibilities of this type of judgments are there. We're making reference to Article 78. Well, in order to eliminate these doubts, we probably will need to get interpretation from the Constitutional Council. What does it mean? Is obliged to suspend the proceedings on the case to refer. So whether it's possible to challenge this, to have the ability to challenge, not related to particular case and actual circumstances of the case. So this can be considered here. Mr. Rogov, I am obliged to remind you of time limits. Well, I will finish at that. I think our discussion was quite interesting, and thanks to the problems that we discussed, the lawmaker and the subject that will submit the relevant legislative proposal to the parliament will take correct decision. Thank you. Thank you, Mr. Rogov. I see that Ms. Raisova wants to express her opinion. She is a lawyer member of Judicial Council. We have another participant who is willing to express his comment. Mr. Arona Manjolovich, please, the floor is yours. Is director of the Institute of Law and Statehood under the Al-Farabi University.
And dear Kairat Abdurazakovich, dear Igor Ivanovich, dear participants, the topic of the roundtable, the referral of cases to Constitutional Council by ordinary courts, is highly relevant from the perspective of the transport security. Why am I talking about this? We listened to the report by Mr. Tennessee and we listened to the report by Ali Pasha. And that made me think about the following. So I'm going to formulate my thought in half a minute. In Almaty, a young driver in Karasai area ran over a woman of 54 years old and her son who was 8 years old. And that happened at the traffic light, the pedestrians line. And, you know, there are a lot of cases, a lot of traffic incidents like that that take place on the roads of Kazakhstan. And usually that happens in those places which are intended for pedestrians only, for the pedestrians to cross the road. And that actually is the violation of the article of the Constitution of Kazakhstan that says that the life of a person is the highest value. And that also undermines the principle of the traffic rules, because we all understand that the human life cannot be returned or restored or according to our, do you think that in case of such tragic situations of Kazakhstan, to what extent the constitution of Kazakhstan remains highly relevant? Because the courts need to take into account the fact that the constitution says that the human life is the highest value. And when we look at the legislation in the field of transport security, this legislation is regulated by legal acts which have proven their effectiveness. But when it comes to the life and health of pedestrians, and the fact that the drivers can deprive the pedestrians of their life and health. What are we supposed to do in this situation? Of course, it's obvious that the drivers need to have a clear vision. They shouldn't drive under influence and so on and so forth. But you know, in the recent years, there have been a lot of cases when the drivers were deprived of their driver's license because of DIU. Uh, if we do not make this legislation more severe, maybe we will have more very sad cases when mothers with their small children die on the roads. For instance, Ayjan Jumashevna, when she was giving her speech, she mentioned about giving the right to lawyers or to advocates to file a motion. With the pandemic, I believe that a similar norm is required. So that's my question. Arona Mandrolovich, thank you so much. We did not consider specific examples, but as far as I understand from your examples, your examples have already been covered by the regulations, and I'm pretty sure that people have been attracted to criminal liability for their deeds. When it comes to infrastructure, well, that's another issue. For example, we are not trying to highlight certain fields of law. We are highlighting everything, and our proposal is aimed at this only, and hopefully we'll get some positive results. I have a question. Sorry, I already gave the floor to Madam Raisova. Good afternoon, dear colleagues. Dear Kairat Abdrazakovich, I would like to thank you for the invitation to take part in this roundtable. I would like to mention several things. First of all, the constitutional law that provides the right to go to the Constitutional Court has not been implemented. In order to implement this law, I believe that it's necessary to supplement the procedural codes with the right to file certain types of motions. As of today, all procedural codes of the country have this norm about the right to file a motion. And I think that if we could clarify this in the codes by indicating a certain type or a certain form of emotion, given the foreign experience, given the international experience, from what we have heard from the speech of Mr. Bukikyo, well, there are two types of forms, individual emotions or preliminary emotions. We we're quite interested in the experience of Moldova because from what we have heard, they have a special register, and I think that that would be quite useful in our context if we have developed a certain register with different forms on the basis of additional norms of the procedural codes and regulations. That would be quite useful for the lawyers and legal advisors, because they wouldn't think about how a certain law could be implemented in practice. I also think that we need to pay more attention to such motions. A decision on such motions shall be issued under a different act. The discretion of courts or judges is another issue. I think that, first of all, here, the motions filed by legal advisors or lawyers are remaining open until the final completion of the case consideration. I think that it's wrong if we supplement this with, norms, and I believe that it would be much better. Uh, Also, it would be much better to list the reasons for why the motion has been declined. it's necessary to clearly write down the cases in which the courts have a right to decline the motions of the parties. I think that such a right needs to be provided to party to any process, whether this is a civil process or an administrative one. And I also would like to draw your attention to the experience that has been shared by our experts from France and Moldova. Well, I actually noted that there are special trained lawyers there for our lawyers, for our legal advisors. It would be good to provide these kinds of trainings on the practices that have been mentioned by our international colleagues. Of course, when it comes to the development of such a draft law, the draft law will need to focus on the special training of people out of the lawyers and legal advisors who could get more experience in the field of constitutional law. I would also like to mention the following. Natalia Vissarionovna is here with us, and well, she mentioned in her speech that there were a lot of different issues, and in May of 2020, the government took into consideration these set of issues and different kinds of inferences. So I believe that it'd be correct if when we develop any kind of draft law, if we carried out some research of relevance. If such research were conducted among lawyers and legal advisors, I think both professional groups could confirm the necessity of this norm, and as a bar community, as the lawyers community, I believe they would support these norms. Since not all the projects are being published and not all the projects are available, the legal advisors and lawyers are somewhat limited in their access. That is why, hopefully, in the future, we will be provided with this access so that these kinds of research among lawyers and legal advisors could take place. Thank you so much for this opportunity to speak up. The material of today's roundtable was very interesting. Thank you so much. The floor goes to Udartsev Sergei Fedorovich, the Doctor of Legal Sciences, Professor, and the Judge of the Constitutional Court of Kazakhstan. Thank you, dear Kairat Andrazakovich, Mr. Gianni Bukikio, dear colleagues. I would like to draw your attention to several points in terms of democratization of the public life. It's necessary to strengthen the Constitutional Council. It's necessary to improve its role in ensuring sustainability of a more dynamic system, because the society is becoming more dynamic and the Constitutional Council needs to be more active in order to counteract this dynamic. Otherwise, it will result in more delays that eventually will become destructive. So since the list of applicants to the Constitutional Court or Council is increasing, I believe that there are several options to make the Institute more active under Article 78 of the Constitution. It seems to me that the words of Kairat Abdrazakovich about the needed interpretation, well, I think that these words are highly relevant right now because the article of the Constitution now needs to be interpreted. So I would like to talk about what is needed in this interpretation. First of all, it's necessary to somehow align paragraph 1 of Article 77 and Article 78. Paragraph 1 of Article 77 of the Constitution says about the judges. Everything is confined to judges in this article, and a judge is a main figure. he resolves issues on the basis of the laws of constitution, whereas Article 78 talks about courts. Obviously, the courts in this case are represented by judges who implement justice. That's the first thing. Second, it is necessary to provide a better interpretation to the word discretion. When something is considered at the discretion of a court, but there are a lot of meanings of the word discretion, and there are some softer synonyms of the word discretion, and you don't need to be 100% confident when you make a certain decision. There are a lot of synonyms to the word discretion, and that is why I believe that the interpretation of this term is quite ambiguous. There is one more thing to take into account. It seems to me that the legislation needs to be amended, and Igor Ivanovich started talking about it. I think that there must be one more justification for appealing to higher instances. Particularly, that needs to take place when the court or the judge declines the appeal to the Constitutional Council. If the judge declines this motion or an appeal, a party needs to have a right to still file a motion. We just need to update the list of reasons or justifications or the grounds for filing a motion or a referral. One more thing. The parties now come up with different types of conclusions. There are a lot of commercial disputes, there are a lot of other disputes with different kinds of interpretation, but who prohibited a judge to use the constitutional expertise in case he has some doubts about his ruling, or who prohibited a party to a proceeding to provide a conclusion about, the compliance of certain things with the constitutional norms. I think that this issue is somewhat neglected, and I believe that if we paid more attention to these issues, we could see a lot of interesting things. So I believe that we need to think about all aforementioned. Igor Ivanovich probably knows that there were a lot of illiterate motions or complaints, but given the active role of a judge nowadays, this is a double-barrel gun. When a motion is sent to the Constitutional Council, when a referral is sent to the Constitutional Council, a question arises. What's the point in case the parties cannot really justify their motion? What's the point? What's the whole purpose? I believe that in such cases we need to be more careful, because otherwise we risk undermining our position. That is why the active role of a judge, which we observe right now, needs to be taken into account, especially when it comes to the references by a judge to the Constitutional Council. Because there are sometimes some informalities which can be eliminated by a judge himself. Thank you for your attention.
Спасибо.
Thank you. Kairat Abdurazakovich, may I express my opinion? Leila Sultanovna wanted to express her opinion. Zhakayeva Leila Sultanovna, the professor of Academy of Justice under the Supreme Court. Leila Sultanovna, please unmute your mic. Thank you very much, Kairat Abdurazakovich, for having this opportunity to express my opinion. I have professional interest in this topic and experience also in the Supreme court where I supervised the questions of referrals to Constitutional Council, and I wanted to provide additional information. Here, now I act as the professor, not as a civil servant. During the work in the Supreme Courts from 2013 to 2019, I can say that the activity of the judges was not high. Well, we provided that we delivered professional support to judges. When needed, we provided them consultations on certain questions, but we didn't limit the initiative. Well, I know that many judges refused to refer to Constitutional Council as they were not confident in the enough groundness, or they were not confident in winning that, and therefore they thought that there was no need to take time and resources of the Constitutional Council and to increase their loads with their requests. So we provided our opinions to the referrals that were sent to Constitutional Council as other state authorities, as it is mentioned in the laws. We provide our opinion. It can be opinion in favor or against, but anyway, always we supported this initiative. And I wanted to say that in many cases, like let's say, our legal reality is guilty, if we can say like this, as it can help to quickly fix the constitutionality of certain norms. What I noticed is that that was the active position of law enforcement bodies, all law enforcement bodies, like with the use of the legal process. Second, you probably know that through explanation of the legislation, certain questions can be also resolved by the Supreme Court of Republic of Kazakhstan, as we have the right to interpret and explain the norms of the legislation, not with regards only to judicial practice, but also given the fact that in certain cases we can explain the process of constitution application and practice. I support the initiative on expanding the possibilities to refer to Constitutional Council through courts, but I have certain concerns, but they are solvable, to my opinion. I just wanted to focus on the following. In the theory of constitutional law, there are certain divisions between the judicial bodies, like constitutional courts, and quasi-judicial constitutional control bodies. And functionally wise, I think this division should be kept. As for the comments of our distinguished scientists that we can exclude certain legal acts, I want to tell that on the level of the law, it's quite rare we can find the unconstitutionality of certain norm, as it is linked to the fact that in the lawmaking process, many state bodies are involved. As for, well, I think that further there will be focus on other legal acts. And from this standpoint, we have a perspective in terms of the fact that with the bringing into force of administrative procedural code. Why? As the courts will consider public legal disputes that are supported by attorneys, advisors, and also with the participation of the prosecutors. And I think here this mechanism will work. Why? But the final word will be with the judge. Why the judge? As it goes through the court. Of course, as for the parties who do not have professional legal knowledge. Of course, here the judge will be in the superior position. In the case when the party to the process will be an attorney who has this legal knowledge or prosecutor, of course, then the process will be different here. And I wanted to mention that if there are strict frameworks for consideration of these motions, and that there is a need to detail this justification. This will increase the loads on the judges. I want to ask the developers of this draft law is to focus on the fact that the main activity of the judge is judicial proceeding, but things related to constitutional control are additional one. In general, I wanted to say that in this case, we support this draft as it's quite valuable for Kazakhstan, and Kazakhstan has certain specificity in terms of constitutional proceedings that have many positive sides. Here, I see one of the explanations that this institute was not quite actively used. Another moment that was discussed in the Constitutional Council, consequences should be taken into account. The consequences that certain acts will be found unconstitutional, especially related to civil legal relations. As you remember, according to legislation, if certain acts is based on which the judgment on civil case was based, that there is a need to renew the proceeding based on the newly opened facts that will happen based on the judgment of court. So here we should work on the consequences if we want to have an active role of judges. Thank you for your attention. Thank you. The next floor goes to the Director of Expert Institute of European Law and Human Rights, Professor Bashimov Marat Savetovich. And then we will finish with that our discussion, as we will have a meeting with the Venice Commission experts also. So, Marat Savetovich, please, the floor is yours.
Kairat Abdrazakovich, thank you so much. There are two important things that I would like to highlight. This conference is very important, and it brought together a lot of international and national experts. In the very beginning, you said that we need to pay more attention to, you know, what is striking? The Supreme Court, in the context of those processes that the government is implementing right now, the Supreme Court was supposed to initiate the active promotion of this idea of referral to the Constitutional Council instead of the Constitutional Council doing so. So I believe that the fact that you do it is quite positive, that it creates more respect for you. You also mentioned that the draft law on the human rights ombudsman is under the process of development. So since our colleague from Moldova is here with us, I just wanted to mention this. In Moldova, they call it parliamentary advocates, and in many countries, they have a lot of procedural powers, like the ability to address to constitutional courts or councils. In this regard, I believe that it is very important for us to start thinking about these powers. One of our colleagues also mentioned this. In, for instance, public disputes, the human rights ombudsman has a lot of procedural powers, and he acts as the third party, and he can facilitate the proper or effective work or handling of motions or references to the Constitutional Council. I just wanted to focus on the support of the legal status of the Human Rights Ombudsman, and that's what I wanted to say on my part. Thank you so much for your attention. The roundtable itself was very interesting and it's highly important, and I believe that it will even more promote the protection of our constitutional rights. Marat Savetov, thank you so much for your comment, dear colleagues. Now it's high time for us to wrap up. We had a very fruitful work. We've listened to a number of interesting reports, interesting presentations during our roundtable. And during our discussions, we talked a lot about the improvement of the mechanism of the referral of cases to Constitutional Council. Hopefully, this roundtable made it possible for us to identify issues and to keep looking for the solutions to these issues. I believe that ensuring the highest legal force and constitutionality are a prerequisite for the civilized development of any country. And in case of a modern Kazakhstan that preferred to choose the path of democracy and democratic modernization, this is even more important and relevant. Our efforts need to be aimed at the provision of the most important values of a country, which are the human rights and freedoms. As the head of state, Kassym-Jomart Kemelovich Tokayev, noted a couple of days ago during the fifth session of the National Council of Public Trust, international standards and the best practices must be spread out in all aspects of the human rights protection. And the policies in this field must be implemented stage by stage in the format of the national indicators, which starts with the assessment of the observance of human rights, particularly 14 global indicators which have been developed by the UN Human Rights Higher Commissioner. The conclusions and recommendations of this roundtable are quite relevant, especially in the light of the initiative proposed by the President, because they mostly cover the issue of protection of constitutional rights and freedoms. And the constitutional control bodies play an important role in the implementation of constitutional values. Our common goal is to ensure the rule of law, to ensure the protection of human rights and democracies. I hope that this exchange of knowledge and experience will make it possible for us to find the optimal solution when developing legal acts and regulations. I thank all the participants for your active contributions. Especially, I would like to thank our partners from the Council of Europe, from the OSCE, and from the Venice Commission. And I would like to thank the experts who provided their speeches. Would like to thank our technical specialists and interpreters who made this roundtable possible. All the reports are going to be published in our Herald. I declare the work of the roundtable closed. I would like to thank all the participants. I ask the members of the online meeting to stay here because we're going to continue our work. Thank you very much for your attention. I would like to once again thank the participants of today's roundtable.
Приглашенных для встречи. Вы все знаете. Или список надо опубликовать.
We are going to have another meeting with the experts of the Venice Commission of the Council of Europe. So we ask Жакипаев Кайрат Тулигенович, Айтпаева Саулия Муханбердиевна, Мусин Канат Сергеевич, Тукиев Аслан Султанович, Пан Наталья Виссарионовна, Жакиалин, Айдос Жанарбаев, Аталыков Hasan Bazarbayevich to stay with us. Natalia, I know that it's your birthday today, but it seems like you'll have to stay with us until the end of your workday. Hopefully, we're not violating your constitutional rights. We also ask the following individuals to stay with us for the meeting with the experts of the Venice Commission. And we ask Баймуханов Кадыржан Расмуханов, Сабирина Ижан Жумашевна, Башимов Марат Советович to stay with us. As for the representatives of the Venice Commission, Шнуц Рудольф Дюр and Kuznetsov Sergei Anatольевич are also here with us. Sergei Gennadievich, we're going to have a second part of our meeting only for a specific group of people. If he wants to stay, please feel free.
Хорошо. Еще раз добрый день, уважаемые коллеги.
Good day. Once more, again for distinguished colleagues. Good evening for our Kazakhstani colleagues. Distinguished ladies and gentlemen, so we continue. So currently, Venice Commission works on preparing the opinion regarding the proposal of the Constitutional Council regarding today's topic. So the reporters of the Venice Commission will have meetings with state bodies and those who deal with the protection of legal rights. So therefore, we organize this meeting. So we would like now to pass the floor to representatives of Venice